First of all, I just wanted to say that I'm really pleased to be the moderator of this panel with such a set of distinguished speakers. We are running out of time. We'll try to be very efficient. I promise to be a very efficient moderator and make sure that all the panelists keep to the assigned time. This session will be on market power of the large internet platforms, public policy instruments to identify market power and avoid abuse, and the current and prospective response of competition law. So it's a huge number of topics. All of them are extremely relevant. We've been talking about these issues in the competition fora for a long time, so I think this is a good opportunity to reflect on the main lessons that we have learned so far, and drawing from the experience of the seasoned specialists we have in this panel, enforcers, people from the IT sector, legal practice and economic consultancies. And we will first look at how the definition of the relevant market and the assessment of dominance needs to be adapted in the presence of online platforms. And we will have to take into account things like, in fact, things that have come out in the previous panel, like multi-sided markets, sometimes with zero prices in one side of the market, high returns to scale, how data plays a crucial role in these markets, and last but not least, that there's the fact that there's a lot of investment going on in innovation. And then the fact that this makes that market shares are not always the best way of reflecting market power in these markets. And then once we've analyzed this issue of market power and the market definition, we will move into how antitrust enforcement and merger policy has taken place in this arena. So to talk about these extremely relevant topics, as I said, we have a distinguished set of speakers. I'm sure most of you will know all of them. I will just go through the bios very fast, because I have a lot of pressure about the time, so that's why I'm running so fast. On my right, I have Monica Cunningham. Monica holds law degrees from London, Paris, and the College of Europe. She worked for international law firms in Brussels and London before joining the UK's Office of Fair Trading in the legal department. In 2005, she joined DG Comp and has worked successfully in antitrust policy as a speechwriter for former DG Philip Lowe and former Commissioner Joaquin Almunia, and as an antitrust case handler in the energy sector. And she currently works as an antitrust case handler in the IT, Internet, and Consumer Electronics Directorate. On my far right, I have Enrique Cañizares. He's a partner of RBB Economics, based in RBB's Madrid office. He has been working as economic consultant since 2000. Enrique has advised clients in merger cases notified to the European Commission and also to National Competition Authority in Spain and other EU countries. His recent experience also includes a number of Article 101 investigations related to information exchanges, horizontal cooperation agreements, and he has provided expert testimony before national and international courts and arbitration in a wide array of cases. He has worked across many different industries, most notably in telecommunications, where his expertise also expands to regulatory issues and intellectual property, where he has been involved in many cases related to collecting societies' tariffs. On my left, I have Pedro Cayol. Pedro is a dual qualified Spain-England lawyer with over 20 years of experience in competition law in Madrid, London, Washington, D.C., Brussels, and Barcelona. He obtained his Master of Laws from the University of Chicago Law School under the Fulbright program, and a Master in European Law from the College of Europe. Pedro has advised in many complex merger control, state aid, and antitrust investigations, and issuing administrative litigation, civil, and damages litigation in Spain and abroad. And last but not least, I have on my far right, Tero Loco. After graduating from the College of Europe in Bruges, Belgium, Tero Loco practiced competition law in leading firms in Brussels for almost 15 years before joining Google in 2010. At Google, Tero Loco advises on all areas of competition law with a focus on online and mobile segments. He has defended Google in multiple antitrust investigations in Europe and in Russia, including the European Commission's shopping, Android, and the licensing of some essential patents proceedings. Tero Loco is a frequent speaker in antitrust and IP conferences. So as I said, a huge, a very distinguished set of speakers. And now I won't take more time from you, but the way we've established this panel is that each of them will make a short presentation, 10 to 12 minutes more or less, each of them, touching on different topics with the order I mentioned in the introduction. And then I'm sure there will be reactions from some panelists to the others, and then have some time for questions from the audience. So let's start, as I said, with the issues on market definition and market power. And Enrique, please. please, if you want to start. Thank you.
Thank you very much, Beatriz, and thank you to the organization of this conference, and in particular to Pedro Cayol for inviting me to speak here. I just will try to, let's say, frame the issues about market definition and market power that it might be more relevant and probably can be discussed afterwards. And in my presentation, I will also make several references to the report prepared by a number of academics for the European Commission on these topics. I will call it the Kremer report, because you know that Kremer is one of the academics who has been leading this team, because I think it's an interesting report, and I have several views on it. So starting with market definition, which is traditionally in competition investigations like the start of any analysis of market power. I think that market definition in this industry, everybody agrees that it's a difficult topic. Why? First, because we are in multi-sided markets. We have one side of the market where companies are only willing to pay to platforms for being in the platform if the users they're interested in are in the platform. So this is one side of the market. And in the other side, platforms offer the service at very low prices or even zero prices in order to attract users and therefore to attract companies in the other side of the market. So we are in a market where prices are very low or zero, and therefore the traditional tool used to define markets, which is the hypothetical monopoly test or the SNP test, is difficult to implement in this industry. Of course, when I say that price is low or zero, it does not mean that there is not any price. I mean, in this industry, users provide data to the platforms and therefore lose some privacy, and to some extent this is the price that they pay for joining the platform. The thing is that the application of the hypothetical monopoly test or the SNP test using the privacy concept is probably not something easy. So at the end of the day, it's difficult really to define markets or to use the traditional tools to define markets. So here we have the recommendation of the Kremer report, the report for the European Commission, which basically tells us that we should put less emphasis in market definition and go straight forward and identify, let's say, anti-competitive practices, potentially anti-competitive practices. In this regard, I think that given the difficulties associated to market definition, it is true that probably it's not a bad idea to pay less attention to market definition issues, but I wouldn't go straight forward and try to identify potentially anti-competitive practices before really assessing whether we are in presence of platforms which have market power or do not face any, let's say, competitive pressure. So, the analysis of market power and identifying the competitive pressures that these platforms can face is one very important thing here. So here we have a precedent, I think the most important precedent regarding platforms, which is the decision of the European Commission on Google Shopping. I think that in this precedent, the European Commission defines a market for comparison of shopping services, which does not include players like Amazon. And basically, I think that when the Commission does this, basically it pays a lot of attention to the specific service that is provided by Google in this market. And I think that there are alternative ways of looking at this, because at the end of the day, platforms increasingly compete for the attention of users, and also, of course, they compete for the revenues that can be provided by advertisers. So to the extent that you can find platforms which do not provide exactly the same service that the platform in question is providing, but are competing to some extent or to a significant extent for the same user attention or for the same revenues from companies, I think that these platforms should at least be considered as potential competitive constraints and therefore be taken into account into the analysis. So I think this is a first issue about market definition, which is important. Then about market power. I said that traditional instruments to define markets are difficult to implement here. Same can be said about traditional instruments to measure market power. Market shares, we are in markets where competition is for the market, and therefore it's typical to see very high market shares, which does not necessarily mean that there is market power. Then we have also prices and margins. We have industries where most of the costs are investment costs and operating costs are very low. So typically you will see very high margins, and this still does not mean that there is market power. So the traditional instruments are not, let's say, appropriate to assess market power, and we have to look for additional or different instruments. And in this regard, I think that the Kremer report, the report for the European Commission that I mentioned in my speech, focuses quite a lot in what I would say are potential sources of market power. No? And when I say potential sources of market power, I'm talking about network externalities, and here we have direct and indirect network externalities. The direct network externalities are when users value more a platform, when the larger the user base of this platform, but there are also indirect network externalities, which are when users value a platform more when there are, let's say, a larger group of companies at the other side of the platform. It happens, for instance, with mobile services when you have a large body of app developers in the other side of the market. No? So this is one thing that could be a potential source of market power. Then the Cremera report also talks about data. And basically, the main point is that data can be used to, let's say, develop better services for consumers. And in this industry with these characteristics, what we can find is that, of course, it's possible that you can have an inferior platform which is protected from superior rivals because of, barriers to entry, barriers to switching by users, locking effects, and also by, let's say, user inertia. No? Let's say that users sometimes, it's true that they can, prefer default options or go directly for default options and be short-sighted or, focus on certain games and therefore maybe not look what is the, best outcome for them in the long term. No? So all these are elements that the Cremera report brings into attention. And I have to highlight that these are potential sources of market power, no? Because what is true is that, in addition to all these barriers to entry, you could see that a company is sustaining a high market share over time, not because of high barriers to entry, but also because of high innovation, high effort. And I think that economists so far haven't done such a good job in trying to disentangle when you see these companies sustaining high market shares over time, where it is really because of barriers to entry, or it is really because they are superior and are really investing more. No? And I think the example of search engines is a good example, because I think here we have clearly vertical differentiation. I think users can really appreciate that some search engines are better than others. So the question is, why certain search engines are better than others? Is it because they have superior data, or is it because they are investing more, or have invested more engineering hours, are doing a better job in having a better service for the client? No? So I think this is something that we shouldn't forget when we analyze these markets. A few more words about data, which I think the previous panel has discussed it a lot, but I think it's important to understand the implications of data in terms of assessment of market power. I think that data is clearly an asset, and taking into account that it's an asset, I think that we can really think that when competition authorities think that there can be market barriers to entry generated by data, there can be market power generated by data. It can be that there can be refusal, or let's say strategies related to data aimed at foreclosing rivals for the market. I think that this is questions that we have, of course, to think about as we think about with all the kind of assets. No? The thing is that, in my view, when we analyze these issues, we have to do a case-by-case analysis and take into account that as regards data, there are several issues that are very important and should be taken into account, several characteristics of data that should be taken into account in the analysis. The first one is that this is a non-rival good. What does non-rival good mean? It means that the same data point can be collected and treated by different companies. And this is a fact, no? And it's something different from natural resources. When you have a natural resource, it's a rival good because if someone is using these natural resources, then others maybe cannot use it. No? So this is something important that we have to take into account. The second issue is diminishing returns. No? And what does this mean? A clear example is when you think about polls for presidential elections. Most polls maybe have like 1,000 interviews and have a margin of error of 3%. If you increase the size of the sample for the poll to 10,000, multiply by 10 the size, maybe you can reduce the margin of error to 1%. So what I'm saying is that sometimes having much more data is not really necessary or does not really make a difference in order to compete. So we can have also to think whether a good sample of data is really sufficient to compete effectively in the market. No? And I think a final point about data is that we have to consider that data is really an ingredient. It's not, in addition to the ingredient, let's say you also have what we could say the recipe. No? In order to do a good service for consumers, I can use data, but I also need for engineering efforts, to do additional things in order for this service to be, a good service for consumers. No? So technology and strategy can also make a difference in this market. No? So I think that the authorities, of course, should look at data and, of course, ensure that competition amongst companies that use data, is on the merits, and is sufficiently vigorous. But I think that we should avoid, let's say, ideological positions about this, which are not sufficiently grounded on evidence. No? And in my view, to some extent, when I see the Kremer report, I can see that some of the recommendations and some of the, let's say, conclusions that they reach are not sufficiently based on evidence. No? I think that so far the evidence in these markets is still developing. So I think we should be careful before adopting such, let's say, recommendations or policies towards these kind of markets to really have more evidence and be based on more, have better decisions and better grounded on evidence. No? And if we find really cases where remedies are needed, I think remedies have to be proportional. No? And I think the Kremer report is right when they highlight a number of risks or issues that we have to consider when we design a remedy regarding data. No? And for instance, when we think about, let's say, bulk transfer of data, we have things like preserving the incentives for companies to continue gathering data and processing this data, which could be probably, undermined, if we design these kind of remedies. You also have, of course, privacy, which it's less economic issue, but we also have the collusive aspects of data sharing. No? So we have to be careful when we define these remedies. And of course, we can also think about other potential remedies in this kind of industries, which can be also, I think this was discussed in the other panel, the possibility or to facilitate that users can take their data out of a platform and transfer it to a different platform seamlessly, which is a different kind of remedy, which is less intrusive and probably could be more proportional depending on the circumstances. And just a final word on market power, and I just finish with this. And is that I think that it's very important also in this industry, and I think in any industry, to also take into account, let's say, the market evidence, the evidence about what is the outcome of competition in the market. And in this regard, I think that it's possible to think also about, let's say, manifestations of market power. And a clear example of manifestation of market power, or let's say a possible example that we can think about, is, for instance, when we think about the browser market, we could see that between 2001 and 2006, Microsoft was able to keep a very high market share in the market, in spite of the fact that it didn't launch any new version of Internet Explorer. No? So in 2001, Microsoft launched Internet Explorer 6. In 2006, it launched Internet Explorer 7. And it was able to keep a high market share in spite that there were arguably better rivals in the market without doing any innovation in the market. No? So I think these kind of manifestations of, let's say, relaxing of companies which are in these kind of industries could also be used as evidence of, let's say, maybe that they are not facing sufficient competition or they are really isolated from competitive pressures. No? But you have other companies which are continually innovating and launching new products in the market. I think this is evidence that we also have to consider. So, of course, I think this brings us to the debate that we always have with competition authorities, which is the competitive level of innovation in the market, which is something which is, of course, difficult to understand, assess, or define. But I think this, for sure, shouldn't mean that we should neglect this evidence. And, of course, we should consider this evidence and see whether really companies are relaxing and probably are not facing sufficient competitive constraints, or on the contrary, they are really innovating and this is evidence that they are really facing competitive constraints. And this is all I wanted to say. Thank you very much.
Thank you, Enrique. So you touch upon many of the issues that that take place in these markets, network effects. You just mentioned innovation, relation between market shares and dominance, and foreclosure effects related to data. We are now going to focus on a specific issue, and it's merger control. And you're probably all aware that we've been discussing in all these competition debates if there has been an under-enforcement in ex-ante enforcement, in the sense that maybe if we had forbidden some of those mergers, we wouldn't have the high techs or big techs that we have right now. So this debate is at both sides of the Atlantic, not only in Europe, but also in the US. But we've also had this recent report, the Furman report, mentioning in particular the case Facebook, Instagram, and how this was cleared in first phase, green light, immediately by the UK Competition Authority. So we are re-looking or rethinking again, are we doing in the right way our merger analysis? I think Pedro will give his views on this issue, on the ex-ante versus ex-post debate. And we have a presentation on this.
Thank you, Beatriz. Yeah, I have sort of a few set of slides just to order my thoughts slightly. I mean, yeah, obviously the sort of topics are just very wide. I'm going to try to just fly over them because we don't have more time. But I just wanted to throw in a few ideas into the debate. Some of them might be provocative, some of them not, but a bit random, really. On the first place, I wanted to just sort of try to encapsulate what the actual issue is we're looking at from a competition policy or public policy standpoint. And then I will give a few thoughts or ideas on tools that I think might be used to prospectively to tackle some of the issues at the stake. First of all, I think something that is in the room has been said a lot, but I think is going beyond the debate of the sort of technicians, competition lawyers, economists, all the rest of it. I think one of the areas that is a concern to society generally is the trend towards concentration. I think that it is a natural instinct in the sort of liberal society to be concerned with large concentrations of power, whatever it is, and in particular economic power. And I think that's something that is the elephant in the room that we're looking at, really. I have rescued some evidence from sources like The Economist or the Economic Bureau Census, which comes later, which suggest that there is evidence of increasing concentration across the board in most sectors of the economy. And you can see the data there. We're not going to read them, but basically the evidence, to put it in summary, says that in most economic sectors, there is a noted trend for concentration in the economy in the last 2 decades. It's a table which I don't think you can see, but basically it's from the as I said, the Economic Census Bureau of the U.S. and it provides this pretty much same kind of evidence on concentration. In the area of platforms, obviously concentration is a massive concern because platforms are everywhere nowadays. They are going to be even more, quite likely, and I think the public pretty much sort of views this with a degree of wariness, concern. As we have seen in the last sessions, prior sessions on the taxi and touristic apartments, all the rest of it, there is certainly a fear by the traditional business models that they're going to be displaced. That's one thing. There's also the concern about data accumulation, which I think is a genuine concern. I mean, as a consumer, I'm genuinely concerned about what's going to happen with all the sort of quantum analytics and all those tools, and how they're going to someone is going to be able to know pretty much everything I do or like. Well, there's also a sort of a slight more regulatory concern, which is pointed out by this CNMC report, which is how large platforms, I'm thinking for instance of Amazon, will have sort of quasi-regulatory powers themselves to regulate once there has been this, the CNMC report also mentions this competition for the market and competition in the market. So once those traders, those businesses are in the Amazon platform, they will be regulated by Amazon de facto. And I think on that, I just made a note there on some old case law on Article 106 in connection with 102 of the TFEU, which I think provides some experience. I mean, there's not that many things new under the sun at the end of the day if we think about law. So I think the genuine question is, should we be concerned as a society with monopoly as such? Is the monopoly as such a real concern? Or is the real concern what monopoly does, what the monopolist does with its market power? And obviously, from a legal standpoint, the response is clear. Our law, Article 102, and the European law in Spain, Article 2 of the Competition Act, basically they say that what is wrong, what is punishable, is forbidden, is not the monopoly, which might have been reached through superior performance or better services, but the abuse of such a monopoly. Well, I mean, on the sort of going to sort of regulatory tools and just flying, and please, Beatriz, feel free to tell me if I'm running out of time. I still have like 2/3 of the presentation to go, but well, there's been some discussion there, already has been on the table today, on whether competition versus regulation. I think that the genuine sort of, I would say, broad consensus is that competition is appropriate as a tool, in particular Article 102, mostly for this kind of conduct, which will have to be refreshed, will have to be maybe updated to an extent, but I think the law is fine. I mean, the other, there has been some reference in the prior roundtable or to the role of regulation and even soft law. as a way to clarify. I mean, on that, the reflection I would like to make right now is that we already have in a number of markets which are vertically related to the internet platforms, such as in particular the telecoms, which are highly regulated or, well, is subject to these ex-ante obligations, which at the end of the day are competition law-based, but they have ex-ante regulatory obligations to deal with bottlenecks. Not only those, competition law-based, but also in terms of data, for instance, there's some sort of more stringent regulations or laws for telecoms operators than for platforms, for instance, in terms of data retention. I think that there is some discussion to be had, and not here because we don't have the time, but on whether those operators, which in a convergence paradigm, like the one we are experiencing, where all operators pretty much tend to converge, and we see that companies in the internet space, like Amazon and others, might go into virtual telephony, for instance, so they're already there. And some others, like conversely, well, the sort of telecommunications operators might want to go into messaging services. So at the end of the day, there are companies which are not so distant, even though they might initially be at different levels of the competitive chain, they might ultimately converge. And obviously, I think that the one idea would be to set a level playing field, a very abused term, to make sure that all of those compete on equal terms, either by fully liberalizing to the extent it is possible in areas where there is competition. For example, in the networks, obviously, in the telecommunications networks, they're highly competitive, at least in populated areas, and either liberalizing or regulating in equal terms for everyone. So just posing the question. One point I wanted to make, a second point on regulation, I think to an extent has been tackled as well, is the issue of why has Google been fined, for instance. We have Tero here, all these multi-billion fines. I think it's the company with most fines ever in Europe, as far as we know. I mean, was there a point for the Commission to act on the basis of a more consensual approach? This has been mentioned a couple of days ago by the head of the Dutch authority. I see that the Bundeskartellamt, for instance, in this Facebook decision, has not issued any fines. And I think there's a point in all these types of quite new business conduct to make sure that companies and well, regulators, if you allow me, or competition authorities work consensually together. And I think in that regard that the Article 9, Regulation 103, 2003. Is a very good setting. I think it should be increased as a policy tool, so really as an option to make sure that we manage not only fines, because they are fines and probably they punish, but I think for consumers it would be far easier to have companies cooperate in a highly contentious setting to achieve solutions that are appropriate. Another area which I wanted to touch is it's also been in the last few years some discussion about breaking up some of these companies. This has been on the press. And well, in the US, there's been one example we all know, the AT&T decades ago, but that was a very different setting, where AT&T was, at the end of the day, not opposed to this breaking up. Article 7 of Regulation 1/2003 provides authority for the Commission to order structural remedies, as does our national law as well. I don't think it's been used. I don't know if anyone in the room knows any example of Article 7 decision where this has been used yet, which what I say is understandable to an extent, because, well, what's in a moment, but these structural remedies have been used occasionally in the context of Article 9, so consensually, with some companies agreeing to those divestitures, particularly in the energy business, but in an Article 7 setting, well, authorities don't seem to like that route. I mean, I think it's understandable, because obviously it's a route which would be highly invasive of property rights, obviously, and I think it would present us with novel questions. But I think that's an answer to those that happily or merrily speak about breaking up all of these monopolies. Yeah. Well. Going to the merger control that you mentioned, well, I think it's already been discussed, some of this. I like this quote by actually a Google executive, and I'm sorry, who said that back in 2010 when Google acquired Android for $50 million, which is a striking amount, taking into account the turnover figures that Google manages nowadays. He said it was the best deal ever. I think he was really right. That transaction went unnoticed. Many transactions go unnoticed. We've already discussed the Facebook, WhatsApp, and all of those. I think the Commission generally acknowledges this in the Kremer report, and before that even. However, the Commission doesn't really propose any solutions. They say we have to wait and see how it works in Germany with this size of transaction threshold and all the rest of it. I think that in Spain we do have this market share threshold. I think many of us, at least from a logical standpoint, like it. Internationally, it's been a highly criticized threshold. Well, I can see why to an extent. I think that those that are familiar with it can cope with it well. My remark for the CNMC, now that we're here, is that I think that there is a degree of under-enforcement. I think it's striking that in Spain we have only around 100 files per year, but very few of those are technology acquisitions. And I would say, and this is of course a very personal remark, that a lot of transactions are going unnoticed, but also in Spain. That's my view. Well, size of transaction thresholds also discussed. I think that those pose many queries. I think German lawyers have a lot of questions how they actually work, and there's probably not enough experience to deal with them. I would say only that size of transaction doesn't really have necessarily any correlation with market power. Well, so there's a lot of things that could be said on the substantive analysis, which the Kremer report touches upon, but I don't think we have that much time. I think that basically the main concern is with killer acquisitions, so acquisitions by large internet companies which purport to kill an emerging startup. And the other concern deals with market definition, which is an issue. I don't think we have time to dwell on that right now. Is there. I just wanted to make a final remark on these new policy tools as well, which are non-strictly competition policy tools. There's a new regulation from a couple of months ago of the European Commission dealing with foreign direct investment, which is aimed, amongst other things, to acquisitions by non-European investors, amongst others, in technology sectors. This is pretty much taken for a US CFIUS experience, and there's some national experience as well. Mostly this regulation is a coordination framework, really. I mean, this is something that remains within the realm of member states' competence, but the Commission will sort of some coordination. And then, well, I think I've jumped over a slide that I wanted to mention as well. The Siemens-Alstom case has been mentioned because another device or tool that is being abused is this notion of public interest, general interest, and European interest when it comes to forming European champions. I think competition lawyers don't really agree with this. There's a lot of other tools like WTO to avoid subsidies from in China, whatever it is. EU funds, if you want to create European champions, you can fund them by using EU champs. Funds, and well, there's other potential tools which are there, like cross-ownership restrictions, which are embedded in our law, for instance, and administrative authorization regimes, which we have some experience, which must be compatible, obviously, with Article 21 EUMR. So I've tried to fly over those, lots of ideas. I hope I'm on time.
Okay, thank you very much, Pedro. Yes, you touched upon many things, not just merger control, but also other relevant issues regarding ex post enforcement. And I think we want to take all the opportunity of having Monica here to get your views on the recent enforcement from the European Commission, and in particular in the Google cases. But also because this report from the special advisors was recently released by the European Commission, I think we would all are looking forward to learn more about the report implications and what are the highlights that we should all bear in mind.
Slides, yeah. Yep, and I think I need the clicker for the slides as well. Great, thanks very much. So thank you very much. It's great to be here today. I have to flag that today is the 9th of May, which, as you all know, is the anniversary of the Schuman Declaration, where Robert Schuman proposed to put in common the production of coal and steel between France and Germany. And I think it's interesting, 69 years later, here we are talking about antitrust policy and digital platforms, which just shows quite how far we've come in that time, which I think is a really positive message. So just to click forward, I do this correctly, yeah. So just quick back to basics. I mean, I'm going to focus on antitrust rules. That's what I do. So Articles 101, 102, abusive dominance, anti-competitive agreements. So what's the aim of the antitrust rules? I'd argue that they're common. They're not specific to the high-tech sector or to platforms particularly. What antitrust tries to do is to make markets work better for the benefit of consumers. And the way it does that is it analyzes very specific behaviors and it carries out very specific analysis in relation to those behaviors. The impact of our antitrust enforcement is first through the changing of the behavior of the companies in question. But secondly, also, that our antitrust decisions, if you like, set a precedent. So other market players, whether in the same sector or other sectors indeed, look at our decisions and, take note in terms of their behaviours, in terms of what the issues are that could potentially come to our attention. Now, obviously in the high-tech sector, antitrust enforcement has faced a number of criticism from both sides, I may say. We're used to that. We're always criticised from both sides. So, the people who say, well, in the high-tech sector, technological developments are so fast that, you don't need to worry your heads about it. There'll be the new kid on the block will displace the entrenched technologies in no time. By the time you've got yourself off the starting blocks, everything will have moved on. So there's no need really for you to do anything. On the other hand, as we've heard today, and as the Special Advisors report also flags, and I'm afraid I'm going to use the Special Advisor report because I think it's disrespectful to our other two members and not just Kramer, although I'm sure they all participated very closely and worked on it. People say we do need to do something, but the problem is, can we? Because given the features of these markets, platforms in particular, the features that we see here, where you've got zero price product, and I take your point, Pedro, that maybe we refer to them as zero price products rather than free products, where we've got two-sided markets, where we've got network effects, and there's the role of data developing. I mean, can we actually deal with these markets with the antitrust tools that we've developed over the last 60 years? Or do we actually need to go for more regulatory solutions to address any problems that there might be? So what's the Commission done faced with this? One, we've pressed on with our antitrust investigations that have been going on for many years. We haven't stopped. We've just pressed on with applying those. We've used the standard tools that have been developed over the 60 years of competition policy. But at the same time, obviously, our Commissioner has been very attentive to the concerns expressed and just to the evolution of the markets and the digital platform markets that we've seen, and that she called for reflection, a broader reflection. I mean, in common with many other authorities worldwide, she called for broader reflection on these issues, just to make sure that we're on the right track. So she launched a public consultation last summer. She held a big conference in January of this year, which I think is still available on web streaming, which raises lots of very interesting issues. And then, of course, we have the Special Advisors report that's been published. But to complement those, and those set forward, as we've heard, lots of issues which are going to be interesting going forward in terms of our competition enforcement, but also our regulatory initiatives at the Commission level. And in that context, I should flag that in the context of the digital single market, there is also a regulation which has just been adopted, which is a platform to business regulation, which I'll touch on a little bit later. Okay, so what have we been doing? As I said, we haven't been idle. And in fact, we've been addressing a number of these issues in the high-tech sector since 2004 with the Microsoft cases, where there we had concerns about, given Microsoft ubiquity with its Windows operating system and PCs, that it was restricting interoperability between those and group servers, and that it was tying, with its Windows operating system, the media player onto the operating system, and subsequently the browser as well. So we brought cases expressing our concerns about interoperability and about tying back in 2004, 2009, where it was actually settled with commitments in 2009, when Microsoft actually offered a choice screen to enable users to be able to select a different browser. In 2017, we had another case about obviously a different sector, about marketplaces, internet marketplaces. Now this is interesting because Amazon was imposing, in the context of its dominant position, I think in the distribution of e-books in French and English, sorry, not French, English and German, it was requiring e-book publishers to disclose to it the best price and non-price terms that were being offered by competing platforms. And so that's an example of the sort of most favoured nation clause that that's dealt with in the Special Advisors report. Then between 2015 and 2017, don't forget we had the big wide-ranging e-commerce sector inquiry. And one of the outcomes of that was, well, there have been a number of cases, but 4 cases to flag in particular were the resale price maintenance cases in the consumer electronics sector. And what's quite interesting about that is, in terms of as a feature of online commerce, if you like, is that obviously online commerce, e-commerce, promotes transparency because everybody can see the price that everybody's charging. At the same time, it allows manufacturers and retailers to monitor what their competition's up to and to intervene if it sees a competition, like by Price Mavericks, for instance, is dampening prices. So it's a sort of advantage and disadvantage, if you like, of the price transparency that we're seeing through e-commerce. And then, of course, we've had the ongoing saga of the Google cases. So this is a case of where within, if you like, a platform, Google has used its position in the Google Shopping case, its position in online search, its dominant position in online search, to ensure more favourable treatment of its own downstream comparison shopping service as compared to third-party comparison shopping services, which were trying to get themselves listed on the Google search website. We've also more recently had the AdSense case, and that relates to the market for advertising intermediation services. Now, Terry, you'll be able to explain a bit better than me exactly what that is, but as I understand it, it's the function that Google has of brokering advertising spaces on third-party websites, where Google used its position in order to require better access for its own service as opposed to third-party services, thus restricting the possibility for third-party websites to actually have a choice of advertisers. And then I'll come to the Android case, which is one that concerns me quite particularly. Now, it's known as the Android case, but actually what it concerns is it concerns search. So effectively, Google, who owns the Android operating system, which it licenses, it's an open source, I mean, you'll maybe explain better than me, but what we did is we looked at this market and we identified that Google was dominant in a number of markets. One of these is obviously online search. Google has over 90% in EEA member states, but also in relation to the licensing of operating systems to original equipment manufacturers. We saw that Google has a market share of, again, in the 90%, and this enabled Google to, when it was supplying the Google apps for that platform, to impose a number of contractual restrictions, which is our contention caused a sort of a lock on the downstream market for search providers. And so they were unable to access the Google Android operating system platform and to reach consumers through pre-installing their services on Google Android telephones. So there are sort of 3 ways in which we have concerns about this behavior. So again, I mean, what's interesting if we put this back in context is, we're not challenging Android as such. We're not challenging the business model. What we're looking at is we're looking at very specific contractual restrictions that Google imposed in the context of this operation of the platform. So first, Google's also dominant in app stores for Android phones, right? And Google basically said to OEMs, if they wanted to install the Google Android, the App Store for Android, the Play Store, on Google Android phones, they would have to also take the Google Search app and Google Chrome. Okay, so that meant that Google Search and Chrome was basically installed on all Google Android phones. Then, having obtained pre-installation of the Google Search and Chrome apps, they also said to OEMs and MNOs that if they wanted to obtain a share of Google's revenues, search revenues, they would have to not install any competing search. So it's basically offering a monetary compensation in return for a commitment not to install any competing search service on Android phones. Now, this was imposed, what our objection to is the fact that this was imposed for each operator. It was imposed that not one single phone that they sold could have a competing search provider on it. So it was a portfolio-wide exclusivity requirement. The third aspect was that Google imposed a prohibition for any operator that wanted, any OEM operator that wanted to impose, to use Google Apps. They would not be able to develop a phone, to sell a phone, using a competing operating system. So they wouldn't be able to market a single telephone using a fork from the Android operating system, so say an Amazon phone, which could be pre-installed with an Amazon App Store. But Google actually said, well, listen, if you want to do that, that's fine, but then you can't use my operating system or my apps at all. And that's effectively the sort of concerns we have there. Now, what we did is we did look quite carefully at the impact of these behaviours on the market and what the effect was. So that's effectively, I mean, we can discuss it, we probably will end up discussing this more, but I just wanted to be quite clear about how specific the issues that we have were. And then turning to the Special Advisor's report, you know, as I think it's been mentioned before, they focused on 3 issues: platforms, data, and mergers and innovation. In relation to platforms specifically, I think what comforts us is that they see a role for competition enforcement. It comforts us that they see that the tools are flexible. So the most favoured nation clauses that I mentioned earlier, best price clauses in the Amazon case as well, and also this role of the sort of action that we can take against self-preferencing. So when you're on your platform, that you're not using your control of the platform in order to favour your own services downstream. But at the same time, they emphasise that maybe we need to consider remedies carefully to make sure that we're actually, you know, achieving, not just by taking prohibition, but that we're actually achieving our objective. And they also flag that not all issues can, of course, be resolved through competition law enforcement. And then quickly, just moving to the platform to business regulation. This is interesting because this is a regulation which, proposed by the Commission, obviously, agreed earlier this year between the Parliament and the Council, and I think due to be published this month, which basically imposes transparency requirements. It suggests that platforms, and this is the point about competition within platforms, is that platforms, in their role as regulator, that they have to be quite clear about the sort of rules they have about suspension of participants, about excluding participants. And that should help, if we like, remove some of the concerns that we sometimes see. And that there should also be increased possibilities for redress for users of these platforms, business users of these platforms. And then finally, just to flag to you, another item that we're doing is that we've adopted a decision on the EU Observatory on the online platform economy. And the idea of this observatory is to collect information with a view to seeing subsequently whether what action is necessary to take. And finally, so just to conclude, I mean, effectively, I guess what I'm trying to say here is that our enforcement has been slow and steady. Slow, I admit, we're not always the fastest. On the other hand, the advantage of competition enforcement is that it's flexible. It looks at very specific behaviours. It doesn't take a sort of overview of the market before seeing what the evidence actually is and where the problems actually are. And I think, you know, I think are showing that we're able to use the tools that we have in our toolbox in order to address some of the concerns. This isn't to say, of course, that, you know, there isn't necessarily a role for regulation. There might well be, but that's something for the future. And of course, there are other linked issues which can't be addressed by the competition rules, such as copyright issues or data protection, as we've seen with the GDPR.
Hello. Hi.
So I can start?
Yeah, I'm sure you will want to react to the many things that have been said, and it's very good to have the view of the enforcer and also the view of someone, one of the main actors in this market.
Thank you very much, and thank you very much for the invitation as well. I have seen many National Competition Authority and European Commission premises and buildings, but this is one of the most beautiful ones that I have seen. It's nicer than Madhu, and I think, as Monica just mentioned. So I'm speaking here today in my personal capacity, so that I can say what I really think, and I think it makes the discussion more lively. I'm a lawyer, but what I have learned during the past 10 years is that law and its enforcement does not take place in a vacuum. It reflects the society, it reflects changes in economies, political changes, and so forth. When it comes to companies like Google in Europe, I like to say that it's a perfect storm that we are facing. Google and other IT companies, successful ones, which right now are typically US ones. And I had an eye-opener a year ago. I met with a very high-ranking government official who was preparing for that country to take over the European presidency. And I met him and he said, listen, Tero, there's this one thing that is really bothering us in this country. And it's the fact that 20 years ago, Europe decided to liberalize or open telecom markets. We had great telecom operators. They were the first one to launch 2G, 3G mobile networks. We had Nokia, we had Ericsson. Everything was going really well, and we opened up those markets. What happened? The American companies came in. They are the ones who developed services that European consumers started to use. And a lot of those services were for free. European companies failed to capitalize on this opportunity. And this high-ranking government official said, Tero, this is the greatest industrial embarrassment over the past 100 years, and that needs to be changed. A lot of things have happened. Of course, we have the sentiment that these US tech companies, they have too much power. They misuse that power. Facebook has had privacy issues. There have been concerns over the democratic process. Impression that tech companies, American tech companies, earn too much money in Europe and yet do not pay enough taxes in Europe. These new platforms, they threaten a lot of the traditional business models. Some of these traditional businesses are very strong, like the publishing industry. Some of the most vocal complainants in all things Google are very strong publishing houses. Where we are a threat, or think of Amazon and the potential implications that Amazon can have on employment in Europe. So there is this perfect storm, and I think antitrust enforcement reflects that storm. Whether it's justifiably or not, that's a different discussion, but that I think is a reality. So I'm actually focusing, I will not be delving into these cases in any great detail, Google cases, but I do want to focus on something which I perceive as a very significant shift in antitrust enforcement that is happening in Europe. Something which can have significant consequences, and yet it is something where the antitrust community isn't really discussing. Now, I hope to change that. I'm not sure I will succeed in that one. And I would like to start with fundamental principles of Western economies and ownership rights. I think politicians like to talk about, well, we need entrepreneurs. I was very encouraged to see the Capify founder and CEO here on the stage today, because it's people like him who create welfare, new businesses, new ideas, innovation. So politicians like to talk about, well, people should take risks. Businesses should invest, be innovative, create new opportunities. This is the way economies grow. This is the way we create welfare for all these European countries. Typically, the idea is that if someone does take a risk, invests, and actually succeeds, it might be physical facilities, it might be a brand name, it might be a distribution channel, it might be an online platform. Well, the idea is that whoever took the risk and invested, well, that one should then freely decide whatever they want to do with that property or asset that they have created. It's for them to use, right? And then over the past multiple decades of European antitrust enforcement, there are some exceptions to this fundamental principle, which is, well, in some situations, actually, you have to share your assets with others, with your rivals, and you have to treat them the same way as you treat your own services on that asset. Now, this, of course, is the essential facilities doctrine, that you have to allow your rivals in and you have to treat them the same way as you treat yourself. But of course, those are very rare cases, and the conditions are extremely strict. That asset needs to be indispensable for those rivals. It's not enough that the asset is convenient for your rivals to use to get business, to get access to customers. It needs to be indispensable. And without access to that asset, the idea is that those rivals would not survive on the market. It is this principle that I observe is being changed. It is shifting. Antitrust regulators, especially the European Commission, they're very good in presenting narratives that people understand and assimilate with. So there's a lot of talk about fairness. In Android, for example, there was a lot of the narrative from the regulators was, well, there needs to be a level playing field. Access to those Android devices, there needs to be level playing field, so Google, rival search engines and browsers need to have the same access to those devices as Google. What they conveniently forget to mention is that those rivals don't pay for the platform. We pay for the platform. We took the risk of developing that platform. It happened to become successful. Those rivals have still free access to the platform. But then the fact that we took the risk, developed the platform, that gets ignored. In shopping, the narrative was very similar. Is, well, Google favors its own services on its own search results. Well, first of all, we don't favor, but that is now being litigated before the court. But it's worth noting that, well, actually those rivals, they already had access to Google search results. We displayed those results. The argument, well, yeah, we have access, so we get free distribution, you can say, but it's not good enough. We feel that Google is getting even better distribution on their own platform, and this is what we had to pay 2.4 billion euros for. We see similar arguments in Apple Spotify complaints, where Spotify says, well, Apple is favoring their own services on their own app store. We see the same in Amazon. Amazon is giving a preference for their own stuff on their own service. And now my question is, if you take a step back at this point and say, well, favoring your own stuff, is that illegal in Europe? Isn't it pretty typical that companies, they favor their own stuff? I like children, but I do favor my own children. So then the question is, well, if this kind of favoring, like Monica just mentioned, or Google favored their own results on their shopping website, when does it become illegal in Europe? We used to have a legal framework which says, well, if it's an essential facility that your rivals need to get access, and they need to be treated the same way as the owner treats their own services, well, fine. But for example, in shopping, the Commission openly said Google Shopping is not an essential facility. It's not. It was very clear from the beginning, and yet we have to behave as if we were. And then the question is, well, okay, fine, so you don't have to be indispensable for your rivals. It's enough that you are a convenient channel for your rivals to get business and customers. Then the question is, well, what does it mean? When does this obligation kick in? Once you have a platform, when do you have to become some kind of a neutral platform? Is it, well, you don't have to be a monopoly, you don't have to be essential. Do you need to be super dominant? Is it enough to be just normally dominant? Or is it something less? And I think there is a lot of legal uncertainty today. With all respect, it's fine to have cases that then become precedents for others, but I don't think after Google Shopping, we have 90% share in search. But then, does it mean that you have to have 90% or more before this obligation kicks in? I don't think so. I don't think the Commission would say so. So this is something that we are struggling internally, and I think there should be some discussion on that. And then I was wondering, when this platform to business regulation was being discussed and adopted, the regulation today imposes a couple of obligations on these platforms that serve businesses. It says, well, there needs to be some transparency on how you rank businesses on your platform, and then if those businesses are unhappy, there needs to be some kind of mechanism for them to ventilate their concerns. And I'm asking, well, if the European law, or if politicians want the law to be such that, well, if you're running a platform, now I don't know if it needs to be dominant, but if you have a platform, then you first have to allow rivals to play on your platform. And secondly, you have to treat those rivals the same way you treat your own services. Why did they not put it in the regulation and make it into law? Everyone now knows, once you have a platform, let's say once it's more than 30% share of that platform, then these obligations kick in. But they didn't do that. They chose not to do that. Why? I don't know. So then the question is also, what is the signal this sends for various businesses? Imagine that someone takes a risk, invests into something, and fails. Those rivals, they are not going to come in and participate in sharing those costs, will they? But then if that investment and risk becomes successful and a success, then rivals will, hang on a minute, you have this great platform, I want to play on that platform, and you shouldn't be fairing your own stuff on the platform, I want the same treatment that you're giving to your own services. Well, why would you then take the risk of developing the platform in the first place? Why would you not simply sit back and wait that someone else takes the risk, waits and see if it becomes successful, and then listen, I have my rights. That platform belongs to me just like it belongs to you. So I think this is a dangerous signal to send. On Android, final word is, and the greatest irony in the Android case is that the European Commission says, well, you know, we applied the Microsoft case. It's a slam dunk. You tie products illegally, you should have known Google, that's illegal in Europe. And the irony is that when we set up Android, we did everything differently from Microsoft. We had seen what happened to Microsoft, and we did it differently. So we did not charge licensing fees. It's free, open source. We don't bundle any of our services with the operating system. There are no Google apps or anybody else's apps on the Android. And yet, we got nailed 4.34 billion euro fines, because what we did was that if Samsung, if they want to have Google apps on the device, they come in a package. If they want to have Google Play Store, well, then they have to take Google Search and Chrome too. And that's where we got nailed for illegal tying. With the one great exception that the European Commission completely ignored, continues to ignore, I hope the court doesn't ignore it, is that, well, we don't take licensing fees for the operating system. We don't have that revenue. We are not selling hardware like Apple does. We don't have any hardware revenue. Where the Commission do you think we get the money to pay for this Android platform? Where do you think it comes from? Well, it comes from Google Search and Google Chrome. These are the ones that pay for the platform. So it's a bit like giving out the free newspaper, Metro newspaper, and you have ads in it. You have to have the ads in it so that you can give the newspaper away for free. We give Android and other services away for free, but it comes with our ads, and the ads are Search and Chrome. And this the Commission completely, they just didn't see it. So the great irony is, we did everything unlike Microsoft. Yet the Commission applied the Microsoft precedent. Hence, we became like Microsoft. We introduced licensing fees. So following the Commission's decision, then we said, well, okay, if we cannot distribute our ad revenue generating services, let's do it the old school, let's become Microsoft. And now then OEMs, Samsung, if they want to have our services, they come with the licensing fee. That licensing fee we all are paying when we are buying our next Android phone. Was this really the meaning of the Commission? To completely destroy the business model? The Commission says, oh, we are business model neutral, but you cannot distribute the service that pay for your platform. Well, then, we have to get the money from somewhere else. Thank you.
Thank you, Tero. Thank you for your very interesting insights. I think it's time for reactions. I'm sure there will be Probably, Monica, you want to react first to some of the things that Tero mentioned, and then we'll keep on.
Sure. So it's interesting. I mean, you mentioned fairness. Fairness is something that our commissioner is very hot on. She mentions it frequently. But the point about fairness is that it's not a specific criterion for the application of competition rules. It's like the sort of ethos underpinning, if you like, the whole system, but it's not a specific criteria. As I said before, what we look at is we look at very specific behaviours in very specific contexts. We carry out legal and economic analysis. And the fact of the matter is that a dominant company under our rules, and this has long been the case, has a special responsibility. And I think that's, it's not as simple as, it's not fair. The point is, when you're dominant, you do have responsibilities that a non-dominant company has. And I think specifically with respect to platforms, you're looking at a situation where, as we've discussed earlier, there are economies of scale, there are network effects, which aren't that easy to overcome, even for a rival that may have deep pockets, even for a rival that may have great technology or an innovative product. Frankly, once the network is out there, once the market position is entrenched, it's not so easy to overcome it. Thirdly, on the question of the ability to monetize, I mean, just because a product is provided for free to the consumer, I mean, we heard earlier that there's no such thing as a free lunch. I mean, a service is provided for free, often, something goes back the other way. The point we have is we look very carefully at the objective justifications put forward by Google in this context, and our view is that they do not justify the monopolization, if you like, of the downstream market that we've seen. It seems to us that there's an ability for Google to monetize its activities, and in fact it does so extremely successfully as far as we know, on general online search. It monetizes the App Store. Google has a number of sources of revenue, and it seems to us, if you like, that the behaviors that I described earlier that Google was displaying were disproportionate to its need to recover its investment.
So very quick reaction then, I think, to the very interesting ideas thrown in on the Google case, to which I'm a complete outsider, so therefore I apologize if what I'm going to say sounds imprecise or whatever, but I mean, I understand as an outsider this notion of indispensability. I think that property, as I understand it under this sort of general civil law theory, is obviously it's not an unlimited right. It has limitations, obviously, and the obligations that a dominant company has might be one of those limitations, but those limitations must be construed very narrowly, I think. And I understand the indispensability point. And it seems to me as an outsider that in this Google Shopping case, I understand it is convenient to be ranked in a certain ranking, but I don't know, it strikes to me like it's not indispensable for a retailer that is powerful to be listed on top, whatever it is. And yeah, I mean, I think that obviously one argument which I don't know if it's going to be made in the court litigation or not is whether or not that kind of sort of a commission decision will clash with property rights as well, because there might be some kind of regulatory taking or sort of akin to even expropriation, maybe. I mean, you are really encroaching upon the value of Google business, I think. So, I don't know. Just ideas as an outsider. And then the only second idea I wanted to make is that, again, as I said in my presentation as well, it would be interesting to understand why this conduct, also in view of what Tero has discussed about the Microsoft precedent, I think we're looking at new business conduct. Would it not have been more proportionate and also better from the consumer standpoint to deal with this in the framework of a commitments decision? That's my question, I suppose.
Yes, very quickly, some reactions on the presentations of the other panelists. On the presentation by Monica from the European Commission, and she explained quite clearly that the decisions taken by the Commission are not about the position, but are about the practices made from that position. When I read the Premier report, I have the feeling, no, that sometimes the Kremer report goes very quickly from, these are the characteristics of these markets, and then we have to look about the practices, no? So I think it's very important also to look very carefully about the position, no? About, as I explained in my presentation, about the position of the players and whether this position is really a consequence, no, of all these factors highlighted in the Kremer report, or there are other issues, no, that explain the position of the. So I think we shouldn't rush, no, to go to the practices, but we should first analyze whether the market power, there is really these high barriers to entry, explaining the high market shares. Then on Pedro, he discussed about killing mergers, which of course is another interesting topic for discussion. I think one of the things that is also interesting about killing mergers is that, of course, when you see what has happened with companies that have been acquired by big, high-tech companies, you see that they have been very successful, no? And one of the questions that also has to be made if you look at these acquisitions is whether the success would have been the same should other company had acquired, no, this platform, or it was a different acquirer, no? So to what extent the success of these platforms is the result of this precise company buying, no, the platform in question. And then on the presentation by Tero, he mentioned the essential facilities doctrine, and I also see in the Kremer report that, they are not really suggesting to apply the essential facilities doctrine. No? To some extent, I think they are relaxing because in theory, essential facilities doctrine is very strict conditions to be applied, and here they are saying that it's not necessarily essential facilities, but to the extent that a practice is likely to result in leveraging of market power is not justified by pro-competitive rationale, then there is, intervention is justified. No? And again, I come back to the market power issue and to really demonstrate whether a company with a high market share is really because of high barriers to entry and so on and so forth, because we are going to apply these lower standards to intervention. I think it's very important. Thank you.
Are there any reactions? No?
Yes, I'm just thinking about, for example, this, and we'll see what happens with the Spotify complaint against Apple. But if you think of it, of course I can see that Apple App Store is a significant distribution channel for Spotify services. But on the other hand, as the European Commission's Android investigation showed, Android is a much bigger distribution platform. Spotify has much more significant access to consumers through Google's Play App Store for free than through Apple. So Apple certainly isn't the biggest distribution channel for Spotify. So it will be interesting to see how the Commission deals with that question, to say, well, Apple is a significant distribution channel, not the biggest for Spotify. Will the Commission say, but yet Apple has a duty to not only distribute Spotify, but also treat them fairly or the same way that they treat their own services. So I think that will be an interesting case to follow.
Maybe I can just pick up on the question of the commitments. It's working, sorry. It's an interesting question, and I saw, Pedro, that you were suggesting that maybe commitments is a way forward. I think from a competition authority's perspective, it's an interesting tool, but it's one that has to show certain characteristics before it can really be pursued. First, obviously, the company has to offer commitments that are suitable. And secondly, they have to offer them in a timely fashion. So I think those are two factors which, for any case, can, even something that you may think, well, on the face of this, it looks suitable, if those aren't put forward at the right time, and ones which are sufficiently far-reaching, and ones that we feel, I think the point is that we need to feel that it's going to change the market. We need to feel it's going to change the market, it's going to change the market in time. If not, we don't have the mandate to adopt.
Okay, I think we have some time for a couple of questions from the audience. Okay.
Hello. My name is Francisco Rocha. I work as case handler here in the Spanish Competition Authority. My question is to Mr. Loco, because drawing on your experience in competition law and also working in a big internet platform, I would like to know your views on the Kremer report. What do you think of the recommendations? Are they on the right track? Would you think they are far-fetched, drawing on their actual economic evidence in this platform world? Thank you.
Yes, thank you for the question. So I kind of refer to what I said earlier. I think there should be, so if there's a legitimate concern that platforms have market power in that they are significant for rivals to get access to, and for those rivals to be treated fairly, and that of course is a big if. But if that is the case, then maybe this kind of obligations should be imposed. But I think it will be very important to make sure that these incentives to invest and create these platforms remain in place. And it also then raises the question of a business model. Different platforms have different business models. A lot of the platforms today are free for rivals to use. The platforms are based on having a lot of services that are being distributed through the platform, and that distribution oftentimes takes place for free. And maybe the platform owner has a business model where they want to monetize their own services on that platform, and maybe the business model is based on that. We will somehow promote our services better than what rivals can get promoted on the platform. If then now there's a rule which says, well, actually you cannot promote your own services more than you promote your rivals, then I suppose it raises the question, well, how do you then pay for the development costs of the platform? And I just wonder whether in the future we start seeing more platforms that have an entry fee, which is, well, rivals, we've created this platform. If you want to enjoy of this platform as a distribution channel, then you have to pay an entry fee. And then once they pay to get access to it, well, then everyone is treated the same, including the platform owners' own services. I don't know whether that would be better for businesses or consumers or not, but I think businesses will have that kind of considerations.
I think there was another question here.
I wanted to express, well, first, thank you, and a concern I have is the fact that I think we're seeing a sliding scale of destructuring the application of basically Article 102 and review for dominance. We are here, it's already some time since we've been hearing that defining relevant market is not so important, because if you have market power, then you can abuse. So you can see the market power because there is an abuse. Now we see that market power as such is not indispensable. And for me, that this thing raises a big question of whether we're going to do reverse thinking. I think that this is anti-competitive, so if it's anti-competitive, the company must be in a dominant position, and then I define the market if necessary. Reading the report also, I see that there's asking for lowering the standard of proof in these markets. I think this is a risk, because what starts as an exception in certain markets with super dominance and essential facility is the perfect example. It started as something extremely exceptional, and now everybody considers that it needs an essential facility. So if you start an exception, like saying we're going to reduce the standard of proof, and that's in the report, or we're going to say that it's not necessary to define the relevant market, I think that at the end we will find ourselves applying Article 102 to many kinds of situations in which it is now unclear that it would be applicable. Thank you.
I'm taking that one. I don't know if anybody else wants to. I'll do a quick word and then I'll let you get on to it. Just to say, just to be completely clear, these are special advisors appointed by the Commission. And I think, there's an economic, legal, technical experts. And I think it's a really interesting exercise because they're able to sort of throw all these things out there. But what they have is they have the freedom that we as a competition authority don't have to sort of throw ideas out there and to sort of see where they fall. So, it's not a position of the Commission, it's a position of the special advisors, just to be completely clear.
No, a very quick reaction to Rafael's comment, actually, because I think I fully agree with the concerns. And there is, I had in my slides, which I was flying over, obviously, for timing reasons, but I had a quote from this Kremer report, which I'm sure some of the lawyers here have noticed, I did at least. At some point they say, and I don't have the slide with me, so I'm sort of trying to remember, but more or less, it said we should even consider that these dominant platforms, they should justify that they are not acting anti-competitively. I mean, to me, as a lawyer, that was a very striking remark. I mean, it's like, I think the right to be presumed innocent, I thought it was sort of fundamental right acceptable to all member states. I mean, so I think that goes in line with what you said.
Yeah. Yes, on Rafa's comment, I completely share your view. When I said that it could be justified not to analyze the relevant market was on the condition that you are going to properly analyze what are the competitive constraints that the company is facing. No? At the end of the day, defining the market or identifying the competitive constraints, I think is the same thing. The only question is that probably the SNP test, the tools that we have used to define markets are difficult to use in this context. And of course, I mean, we cannot go straight forward, to see whether a practice is anti-competitive, because many of these practices that have been analyzed, and the CNMC report itself acknowledges it, have also efficiency justifications. So it's only when it's a dominant company that is using them that they should be a question, let's say. No? So I think it's very important to assess whether the companies really have or no market power.
So we are running very much behind the schedule. I think we need to wrap up now and close. Thank you very much. We could be talking of these issues for hours, and I'm sure we'll have some time maybe after the seminar. But we are now moving to the last part of the meeting. Thank you.
Buenos días. Llegó el momento de concluir este espacio compliance sobre mercados de plataformas electrónicas y desafíos de la regulación y la competencia para equilibrar el sistema. Como miembro de la asociación Fulbright y empleado de esta casa, quiero dar las gracias en nombre de todos a la CNMC por haber acogido este evento y agradecer especialmente a la consejera Ortiz, a la directora de competencia y a los directores de promoción de la competencia y control interno por haber participado en la jornada. Agradecemos también a todos los ponentes por haber fomentado un debate muy enriquecedor y haber aportado enfoques diferentes al de la autoridad de competencia. Han participado 4 despachos especializados: Cayol, Coca y Asociados, Clifford Chance, La Villa y Ramón y Cajal, las empresas BBVA, Cabify, Google, RBB Economics y Telefónica, y representantes de la Comisión Europea, la Agencia de Protección de Datos y el sector del taxi. La Universidad Americana también ha estado representada en esta jornada, ya que algunos de los ponentes han tenido la oportunidad de formarse en universidades como Harvard, Stanford, Columbia y la Universidad de Chicago, a través y gracias del programa de becas Fulbright. Hemos disfrutado de una jornada intensa y enriquecedora en la que hemos tenido oportunidad de profundizar en 3 de los retos fundamentales que plantean las plataformas digitales al derecho de competencia y regulación. El debate ha comenzado analizando los nuevos modelos de negocio que plantean las plataformas digitales, en algunos casos creando nuevos mercados, pero en otros entrando en mercados tradicionales. Como entrantes, las plataformas tienen, por un lado, efectos procompetitivos y que mejoran la calidad de los servicios y mejoran también la eficiencia, reduciendo costes de transacción y asimetrías de la información, pero por otro plantean importantes desafíos regulatorios como la creación de un marco con igualdad de oportunidades y la resolución de potenciales externalidades negativas. Todo esto además se debe lograr, como se ha dicho aquí, bajo el principio de menor intervención pública posible. Hemos continuado con la economía de los datos, que es en la mayoría de los casos el combustible que nutre estos nuevos modelos de negocio. Se han analizado los problemas potenciales relacionados con la privacidad y sus implicaciones en el derecho de la competencia. Se han aportado reflexiones sobre nuevas teorías del daño con el dato como insumo esencial. Y también reflexiones sobre el consentimiento del usuario como elemento de diferenciación competitiva.
Para finalizar, se ha abordado el tema del poder de mercado y su posible redefinición para adaptarse a la realidad de las plataformas digitales como instrumentos de política pública con el fin de evitar abusos y asegurar la competencia. Se ha analizado la respuesta actual desde todos los puntos de vista, tanto de las autoridades como de los agentes del mercado, y reflexionado acerca de cuáles pueden o deben ser los cambios y los nuevos componentes que sirvan de valoración a la hora de enfrentarse a este nuevo panorama en el que los instrumentos para medir el poder de mercado de una empresa han quedado en muchos casos obsoletos. Ha sido en definitiva una intensa e interesante jornada que nos ha permitido escuchar diversas ideas y puntos de vista que nos han ayudado a enfocar muchas de las problemáticas que seguirán, sin duda, dando que hablar y con una gran importancia en las agendas política y profesional de los próximos años. No se le escapa a nadie que las plataformas electrónicas han crecido exponencialmente en el último decenio, adquiriendo un papel muy relevante en el día a día de todo el mundo. La digitalización de la economía ha venido acompañada de grandes cambios y nuevos actores que pueden ser percibidos como una amenaza para los actores tradicionales y, en la mayoría de los casos, como una tremenda oportunidad para la innovación. Y es aquí donde el marco legal y el derecho de la competencia en particular adquieren un papel central a la hora de permitir un crecimiento saludable del mercado que en última instancia repercuta positivamente en los consumidores dentro del actual marco de transformación tecnológica de la economía, interviniendo de la manera más eficiente y evitando las barreras innecesarias. Sin embargo, no parece que vaya a ser posible que el derecho a la competencia pueda cumplir su función si no se lleva a cambio una profunda reflexión con el fin de actualizar y modernizar la manera de interpretar y aplicar las normativas y los análisis económicos relevantes que permitan su adaptación a los nuevos tiempos y desafíos que se han expuesto en esta conferencia. Y sobre todo, los que todavía existen, como hemos visto, muchos puntos de vista opuestos. Por último, ya que ya nos hemos pasado mucho de tiempo, únicamente agradecer una vez más a la CNMC y a la Asociación Española de Becarios Fulbright y pedir un último aplauso para todos los ponentes y agradecer su atención.